So you've talked a little bit about international clients and U.S. versus international filings. What's different in the U.S. compared to international jurisdictions on filing for copyrights and trademarks?
Well, the primary difference internationally for trademark is whether a country is what we call a first-to-file country or a first-to-use country, a registration country or a use country. The United States bases their trademark rights on use. The priority for a trademark owner is the first to use that trademark, and that will happen even when you're looking to register your trademark. The first to file will have priority, but if you want to fight it out later, ultimately the person who has first used that particular trademark in commerce should have priority of use and the ability to ultimately obtain that registration. So filing for a trademark registration is extremely beneficial, but it isn't necessary to obtain trademark rights in the United States. In other countries, and it varies, other countries, trademark rights do require registration. So in other words, the first to register a trademark, whether they're using it or not, is going to have the rights to that trademark. And so in most of those countries, there is a 3 to 5 year period after which that particular registration could be subject to cancellation. But during that initial period, they can effectively block anyone who wants to actually use that trademark, even if they're not using it at all. And that's where you hear stories about trademark registrants holding companies for ransom, right? Like, oh, I forgot to register, iPhone in a registration country. So now Apple has to spend lots and lots of money to get the trademark rights in that particular country. Especially when dealing with large portfolios, that's another area that requires some strategic thinking, because even in countries where you don't yet have a physical presence, but if you want to protect your trademark rights in a registration country, you may very well want to file what we call defensive registrations, just to get a registration in that country, because use is not required. But if you don't file for the registration, someone else could come in and take it from you. And then you're faced with having to refile every 3 to 5 years in order to maintain those rights, because otherwise you're subject to cancellation if you aren't using it in that country. So it can get complicated. But that's the primary difference, whether it's a registration country or a use country.
So you may have a different strategy in the U.S. versus Europe. And if you're a country doing business in both places, you need to be concerned with both sets of rules.
Yeah, absolutely. I mean, more than likely, if it's a U.S. company, which most of our clients are, you would certainly be registering in the U.S. as well. But that would be one of your first considerations, would be to include the European Union within your countries, your registration countries.
So then if we compare that to copyright process, are there similar differentials between European, for example, and U.S. copyright processes and procedures or rules that would apply for companies that are thinking about copyrighting their creative works?
Well, copyright, like trademarks in the United States, registration is not necessary to obtain protection. So the minute you have your expression down in a tangible medium, right? It's pen to paper, your copyright rights exist. It's not required, but obviously it's beneficial to put a copyright notice. We're all familiar with that, with the C in the circle. But obtaining a copyright registration is not necessary for protection. It makes sense for a lot of reasons to obtain a copyright registration, particularly in the United States, because it's going to give you the benefit of statutory damages and attorney's fees if you ever do end up in a dispute over that copyright. But not all countries have copyright registration. I was just working with a client the other day who has a potential project in the UK. So the UK doesn't have a copyright registration system, but copyright is protected. The UK is part of what's known as the Berne Convention. And for copyright, this is a treaty that many countries have agreed and have signed on to that essentially provides international protection for copyright. So it's not as nuanced as of a strategy for copyright, but you still have to think about it. And certainly in the United States, depending on the type of content and whether or not you expect there could be issues with people copying your content, then registration certainly makes sense, because if you don't have that registration, you're not going to have the ability to obtain statutory damages or attorney's fees in the United States.